So this talk is about private law liability. I've noticed that, let's say, for more than 10 years, when people think about cybersecurity and about law, then we immediately turn towards privacy issue, data protection issues, and increasingly also to fairness issues. And I think the moment has come, maybe already for some time, to turn to private law liability. So that means making the entities that cause damage in some way pay for that damage. Let's have a look at a message from the end of March, where the FBI warns of teleconferencing and online classroom hijacking. It's interesting that the FBI warns about that. And one question one could ask is whether Zoom itself should be liable if any damages occur. Here we have a message of 16th April. This is about Zoom bombing. I assume you all know what Zoom bombing is. Harassment by people external of a conference, usually with racist or sexist slurs. Not a very nice experience. Now in this article, you can read how to prevent this, which means that Zoom had installed by that time a set of settings, choices, where you could reduce the chance that this would happen. And that raises a second question. Is now the liability, if something wrong happens, not only or not at all with Zoom itself, but maybe with the conference organizer that did not use the right settings? Here we see very concrete what happens if access to the data has been gained. And this is again 15th April. And of course, now we seem to enter the realm of criminal law, not just private law liability. For those who thought that the problems were over, this is a very recent message from 29th September. And of course, we're not here to discuss Zoom, or not only Zoom, but we're here to move onto the Internet of Things. That means a move from online tools, from software, to what is ingrained meshed up into hardware in new ways. People speaking of cyber-physical infrastructures. This is a message about the fresh smell of ransomed coffee. I don't know if this is something would be very worried about, but the mere fact that this might be possible in the article, the idea is voiced that firmware is the new software. I assume this is all not news to this audience. We're talking about IoT, healthcare, connected cars, smart energy grid, smart city, smart home, smart offices. So increasingly we're talking about infrastructure, interconnectedness, differences between hardware and software becoming different. And what interests us as lawyers is what happens if damage is caused, harm is caused. And as you can see here, a message about a hospital being hijacked and ransomed, and meaning that the IC had to close and somebody had to be moved to another IC and died on the way. So I think it is very important for computer scientists to take law seriously. And I've taken this very seriously myself. I had the privilege to teach law in cyberspace to master students of computer science for 8 years at Radboud. I always say it was party time, and I'm confirmed that my successor, Frederik Zuiderveen-Borgesius, has exactly the same experience. So it seems that lawyers and computer scientists have a lot in common, besides also being very different disciplines. The 8 years that I've been teaching this, I validated that in terms of a book, a textbook. The link is in the slides. I hope you will take note of it. There is a chapter 8 there in which I discuss private law liability for faulty ICT. And I end that chapter with saying that I expect that a combination of private law liability, data protection law, competition law, and consumer protection will be taking the lead in reconfiguring the legal landscape of what I call the on-life world, that is the blurring of the borders between the online and the offline world, where the whole idea that these are different worlds becomes something artificial. So the distinction becomes artificial. And I think the new legislation, all the case law that is pending, should contribute to more adaptive legal protection and a better distribution of checks and balances between technology developers, manufacturers, retail, service providers, and end users. What I want to do today in this talk is to look first at different types of harm, and especially at 2 levels of looking at harm, which relates to how law deals with harm. Then I will focus on tort liability. Tort liability means that somebody has damage and is trying to make somebody else pay for that damage. And in law, of course, there are a lot of conditions before you can do that. We'll start with a look at the EU level, then go into the specific legislation of look at white paper on AI from February 2020, where they announce a lot of potentially new legislation, new legal frameworks, and maybe reference briefly the fact that the enforcement of the GDPR is in part also based on the possibility of making companies or public administration liable under private law for damages. And then I will try to explain the difference between risk and precaution. So let's first look at AI harms at 2 different levels. On one hand, there is specific identifiable damage or harm of an individual. To be able to sue for that sort of harm, that damage must be identifiable as a discrete sort of damage of that individual. And as you may have noticed in the case of, for instance, a data breach, where enormous quantities of personal data are hanging out somewhere on the dark web, and often this is kept for some time before it is sold, and that sometimes can be some years. It is very difficult to prove in a court of law the damage that an individual has suffered because of that. Nevertheless, it is possible also if you think not only of loss of personal data, but if you think of faulty ICT in the sense of causing death or harm, or products that have broken down, to sue for that in court. And under private law, that is basically done under either breach of contract, so you have bought something and it turns out that it's not operating as you should have been able to trust, or if you did not have a contract, but you're making use of a service, and there is a third party involved, and due to the involvement of that third party, you suffer damage, then you can still, even if there is no breach of contract between you and that party, sue for damages. This also makes possible to file for an injunction, and I will quickly make a sidestep to the GDPR already. Because it is so very difficult to prove damage in the case of violations of the obligations of the data protection regulation, There is a very interesting article in the GDPR, Article 79, which says that irrespective of your right to go to the data protection supervisor, you should be able to go to a court to require that that court stops the unlawful processing. So that would be an injunction. That means that the court tells, if the court agrees that there is unlawful processing going on, that the court can tell that entity that is doing this, so the controller in terms of the GDPR, to immediately stop with that unlawful processing. Just try to think of everything that has to happen at the back end of that system to make this real. And the court could add penalty payments for each day that an entity does not comply with that order. And I think that this type of injunctions will in the end be much more effective than trying to prove damage, which takes a long time in the case of unlawful processing of personal data. Okay, so this is when you look at the level of individuals. Obviously, the implications of moving towards an IoT, towards cyber-physical infrastructures, has many implications at the level of society, where it would be a bad idea to wait until the damage is there. For that type of potential damage, we have administrative law. For instance, the GDPR. Things like consumer law, think of the Directive on unfair contract terms, where if a company forces you, if you want to make use of their services, to sign the terms of service containing all sorts of terms, so conditions that are forced on you, that the law considers by default unfair, then those terms, even if you sign for them, are not valid. Third, there is a whole conglomerate of safety laws, for instance, the Machinery Directive, the General Product Safety Directive, that imposes all kinds of duties on those, for instance, who put potentially dangerous products into the market. So here you have this other level of addressing harms that are more at the level of society, where it is difficult to individualize the harm, and also not a very good idea to wait until such harm has surfaced. Now, I want to focus here on, nevertheless, on that private law liability, so the individualized harm. We're in the realm of private law, not public law. And it is good to remind ourselves that there are two goals for that. One, to compensate the harm suffered. That's again the individual level. But of course, in the end, the idea is also that if entities, for instance, entities that have a certain business model, that if they have to pay for the harm suffered, that will generate some deterrence and prevention. So in a sense, private law liability tries to also give an economic incentive to reduce this sort of harm. And in that sense, you can see that even private law liability has certain societal level aims. Okay, let's look more closely now at tort liability. And let's take the EU level. Why is that important? Because we're talking about the Internet of Things. That's not going to stop at national borders. Now, if you look at tort law at the EU level, maybe surprisingly for some, this is actually mostly national law. So the EU has little competences to engage in enacting private law. And for the member states, it is very important to stick to their own regime. Nevertheless, there's been a lot of work done on trying to map how different member states have settled all these issues of, in this case, tort law. So I'm going to sort of infer from all these different member states a kind of generic level where you can say, well, that's basically everywhere the case. And maybe that's also the right level of abstraction for this conference. So important is, the default is always that every person bears their own damage. That's the default. And tort law, and also breach of contract, which we're not discussing here, is the exception to that. So if you want somebody else to pay for your damage, you will need to prove certain things. And the first thing you have to prove is the damage. And that may sound very obvious, but as I said in referring to personal data breaches, this is not always obvious. And sometimes it is unclear what the damage is. In some cases, for instance, immaterial damage can be claimed. And in other cases, only the damage to, for instance, tangibles or real estate can be claimed. In some cases, economic damage can be claimed. In other cases, only the direct damage that is caused to things or people. The second thing that has to be proven is that there was a wrongful act. So somebody acted in a way that they were not allowed to act. And that can also mean if somebody refrained from acting whereas they should have, that's called negligence. So if you have a duty to act in a certain way, and you don't, you can be sued for negligence. What is then very important is that you must also be able to prove that this wrongful act was actually committed by what we call the tortfeasor. That is the entity or the person who committed the tort. So you have to both show that it is this particular entity that you're suing and not another entity that has caused this damage. And that also means you will have to prove normally the causality between that act of that particular entity and the damage. What I've just described is what we call fault liability. That means the full burden of proof is on the injured party, or what we usually call the victim. In some cases, the legislator believes that because it may be extremely difficult, if not impossible, for a victim to prove that it was this particular party who caused the damage, for such situations, sometimes we have strict liability. That means that if you prove damage and you prove the causality between your damage and the wrongful act, then your burden of proof stops there. This was born, for instance, from a situation of asbestos, where 30 years after being exposed to asbestos, people became terribly ill, and it was often impossible to prove which of their, for instance, previous employers had actually caused this damage. I'm going to immediately move on to product liability, because here we will see a modulation of strict liability. Product liability is something that is actually settled at the level of EU legislation. And that means all over Europe and all the member states has been incorporated into national law. So there is the Product Liability Directive at the EU level that is being translated into national legislation. You could say that this is about a mitigated strict liability. It basically reverses the burden of proof in part. So like I said, if you have damage, if you can prove that the product that you bought has a defect, and if you can prove causality between the defect and the damage, and you is the injured party, then by default, the manufacturer must pay compensation for that. And they have some opportunity to prove that they could not have acted otherwise, etc., etc. But to a large extent, behind this sort of liability is the idea that if you take the risk of putting that product into the market, and that product may have some unknown defects, that you are going to pay for that risk because it's your business model. So actually, it's a very pragmatic way of dealing with things. Now, there are a lot of problems between the Internet of Things, between software itself, especially, between the integration of software into hardware, into infrastructures that have caused in February the European Commission to publish, together with its white paper on AI, a report on safety and liability implications of artificial intelligence, the Internet of Things, and robotics. Why did they decide to do that? Yes. So let's first have a quick look at how the current Union product safety legislation is put together. And you can see that there is already a lot out there. But this is legislation from quite some time ago. And for a number of reasons, it's not enough. But you can see there are general rules, essential safety requirements. Of course, standards play a big role in that. There is conformity requirements based on, for instance, certification. There are self-assessments. Sometimes there are third parties who do assessment. Then you have more specified safety legislation, and I especially like to mention the machinery directive. So the CE label that is on all kinds of products. Anybody who wants to put a product on the EU market that may have dangerous implications will have to carry this CE label. And there are a whole lot of conditions, a lot of hoops that company or legal entity has to jump through before it can be put on the market. And then we also have the overarching general product safety directive. So this is all very interesting, but this is ex ante. This is before the fact, and we still need to see what happens if things go wrong. And here we go back to the report. In that report, the Commission details why the advent of actual AI applications, Internet of Things, robotics, challenges the current legal framework. And they sum up connectivity. So that means if a lot of things that were previously sort of standalone hardware devices, if they're now accessible via online connections, that raises, of course, many possibilities of being hacked. So think of toys, for instance, children's toys, etc. There is the issue of autonomous systems that may display emergent behavior that is difficult to foresee. The mantra is that because they're autonomous, they will do better. Let's say the jury is still out on this, but it has many complications because a manufacturer can say, well, at the moment when I put this into the market, I could have no idea that the system would behave like this, and therefore I am not liable. This is because the product liability directive has certain, sorry, I was just looking at the clock because we have to remain within the time. Because the product liability directive has certain requirements for the producer that at the moment when it is put in the market, the producer could have foreseen the defect. Well, there are many other things, mental health risks, if people begin to interact with machines, the data dependency, the opacity, complexity of product systems, software components inside hardware, where it is unclear whether the product liability directive applies to that. And of course, the complexity of value change, where often the manufacturer is integrating a whole lot of different components, software components, assembling with hardware, software components, where everybody may be pointing to each other. People talk about distributed causality, and it's very important that the law creates a coordination mechanism. So clarifies that the entity that puts this on the market is liable. Very quickly, the European Commission proposes the following updates at this moment. This is still in the realm of proposition, but they want to speed this up because AI integration in infrastructure is speeding up. So they want to update the definition of product to make sure that when AI is integrated, it falls under this liability regime. They want to reduce the burden of proof with regard to the victim that has to prove that the product had a defect, to tune that burden of proof to the implications of using AI. The same goes for a later defect or a development risk, which are currently defenses, but because many of these systems keep developing, changing and adapting their behavior, it's very important that the law ensures that there is nevertheless liability, extend liability for the same reason beyond the moment of putting something on the internal market. Consider strict liability for damage caused by autonomous AI applications. And I could go on for hours, but I will not do that. And I'm extremely curious for your questions, because I can imagine this is a totally different way of thinking about security. Thank you.
Mireille, thank you very much. And yes, there are a number of questions, maybe even more than we can handle in the remaining time. But let's start with two questions that I think are very relevant also in the context of other presentations that we've had yesterday and today. Question from Martin first. How can we ever be sure that unlawful processing of personal data has been stopped? Isn't it a dead law?
Yeah, I think that's a very good question. But maybe it's good also to realize that the GDPR provides for the data protection supervisors quite unprecedented competences if you compare it with other supervisors. So the data protection supervisor can not only ask for all documentation, expertise, etc., but they can also actually visit premises and look into things, speak to people, get into systems. Of course, this is all, it's a competence that is reserved for the data protection supervisor, because this could cause harm in terms of trade secret, etc. But the competences are enormous. And the interesting thing about the law is that the moment when the legislator feels that it is impossible for instance, a victim, I'm speaking of private law liability, to prove something because that proof is in the hand of the tortfeasor, and to go to your example, if it would be very difficult for somebody who claims that unlawful processing is going on, if that can only be established by the other party, then usually the burden of proof is turned around. That is done by the legislator, but if it's clear to the court that it's like that, we call that a probatio diabolico. So that means it is basically impossible to ever prove it on the other side. Then the burden of proof might turn around, and it will have to be the specific company that proves to the supervisor that they have actually changed their backend system.
Okay, thank you. Actually, your answer may also be a very interesting bridge to the next question from Wim van het Einde, where he says product liability is only for purchased products within the EU, not for products purchased via a Chinese web shop. How do you see that?
Oh, that's an excellent question. I have to look that up. Let's start by saying that. But going saying this by heart, I would say that if it is possible to purchase something like that here, then this would depend on whether that counts as something entering the European market. So normally entering the European market would be that a company buys something in China and then puts it on the market here. Now, this is a different situation, if I understand the question well, where a consumer directly buys in China. I would have to look that up, I'm not sure. But it would, of course, be very interesting in terms of reputation if a project that you buy on the market in Europe, that you can assume that it's gone through all the safety legislation, so it is safe. And second, that if something is wrong, the entity that put it in the European market, in the internal market, is liable. Whereas if you decide to go outside of the market, it might be, but once again, I would have to look that up. It might be that you're not protected. So I would almost say that's a boost for the European market because people are going to notice this.
Very interesting. If you ever find it, I know where to find Wim. Last question, because we're running out of time. But I think it was your answer was a nice bridge to that as well. Why care about IoT liability? Can we learn from the IT market? Was ever a PC owner convicted for not updating his PC, causing a distributed denial of service attack?
I can't answer that last question. I would have to look that up. But when I started my presentation, I tried to show that, for instance, in the case of Zoom, and the same goes for any other application. So there is the liability of whoever puts something on the market. Then there is the liability for providing sufficient updates. Now, I understand this is, you're talking about not an end user, but a user, so who has bought an application and allows end users to use that application, but has not updated it. I must honestly say that in that case, it would be quite clear if that causes damage, then it violates a whole range of safety requirements. So the problem might sit in the fact that software is still not clearly under the product liability directive, and that's also the reason why that's going to be updated.